Okay, thank you, Jonathan. It's good to once again sit down with you for a discussion about cryptocurrency and other related matters affecting the industry. So I'd like to start right away without wasting much of your time. Okay, Jonathan would like you to tell us about the background story of the SEC versus Ripple case. Okay, so it's one of the most interesting events that took place in the crypto industry over the last okay, in the last few days, and now we are beginning to see a new dimension. Like it's the most talked about uh, legal case in the industry right now. So, what is the background story of the SEC versus Ripple case lawsuit?
Yeah, so I've been in the crypto space for a couple of years now. Came as an international transactions lawyer, kind of understanding where things are coming from. So my perspective is pretty broad. I'm not really a securities lawyer, which a lot of this hinges on. I'm not really a finance lawyer. I'm more of a broad spectrum, look at all the pieces, put it together, advise the founding team on what to do kind of lawyer, right? So that's my perspective. So I'm always happy to hear from others as well. So if anybody who hears this thinks that I got anything wrong, please correct me. Please let me know, because I know we have, at least in the U.S., we have specialized very much in securities, in token issuance, even in appeals cases, right? We've got litigators to do that. So there are a lot of lawyers who are very smart, and others who are in industry who are very smart, who have following this very closely too. But I'm happy to share my thoughts on what I'm seeing from my seat. So you're right. This decision on Ripple, everyone had been waiting for a long time. I mean, ever since I've been paying attention to the industry very closely, everyone had been waiting to see, how kind of the tack the SEC would take against Ripple, what the court would agree to, and you got to keep in mind that this is a first. I want to say low-level court decision, but in terms of the hierarchy, this is only the first level, right? This is the U.S. District Court in the Southern District of New York. There's still a Court of Appeals in the Second Circuit. And this covers all of the financial headquarters of what we think in the U.S. So very significant in terms of the geography of the decision. And but there's also a long way to go from here. So the background is, for those of you that don't know a lot about, or at least have been following it kind of tangentially, like I was from the early days. It's a pretty typical scenario where we have founders who took the Bitcoin code, wanted to improve it, and kind of replace Bitcoin and make it more functional. So they developed a token. They have smart contract ledger, and they kept about 20% of the minted tokens for themselves, and then contributed those 80% of the remaining tokens to a Ripple Labs entity to develop software to help manage the international payment transactions. So I gotta say it's pretty typical from what I'm seeing in the crypto space. So a lot of companies that have been issuing tokens that want to compete with Bitcoin in some way, and there's really not a lot of functionality beyond that. That's kind of where we're sitting in terms of understanding where this case sits in the precedent. But this was a very early project, right? They started doing this around 2012. So in terms of the U.S. legal system, 10 years is a long time for a project to be out running before getting any kind of legal action against it. And of course, it's taken a couple of years for the court to really come down with its decision. So that's the background. Is we have a free-floating token competing with Bitcoin, a lot of adoption. I mean, the market cap for XRP is fairly insane in terms of overall value. So that's kind of where I'm seeing this in terms of where it fits in the industry.
Interesting. Okay, Jonathan, there is the propensity to describe the sexist action as scapegoating. I think I've had a lot of people say, okay, the SEC chairman Gary Gensler is outrightly scapegoating the crypto industry, actors in the crypto industry, and I think to a very large extent this kind of is the case. So, but from a very legal perspective, I understand the concern of the SEC to regulate the crypto industry, and of course, you're going to have to follow the logic, okay, in terms of consumer protection, and what have you. But what do you consider to be the case as far as the SEC is concerned? Do you consider this to be grandstanding or scapegoating?
I think there is some. So I have a little bit of background on this. I have worked for a summer during law school for FINRA, and FINRA is kind of the principal's office for the securities industry. So anybody with a trading license, all the firms, they all get regulated by FINRA. And FINRA has the same kind of mandate to, their mandate is investor protection, market integrity. And so I feel like that's the mantra that we're talking about here, is how close do these cases hew to that ethos of making sure the market is as clear and open as possible, that investors are protected and know what they're getting into. And I feel like there is some overreaching by the SEC in terms of not being willing to engage very deeply and looking at tokens beyond those tokens that are trying to act as pure currencies. So like I said here, with XRP, it seems to be very much focused on cryptocurrencies. So from my perspective, the way that the SEC came down, the way the court decided this, I felt like it was fairly consistent with my understanding of how I thought it would come down, where we're just dealing with something that looks like a traditional currency. A lot of projects between then and now have tried to add a lot more functionality. We have a lot more utility tokens. We have things that could be classified as security tokens, but they're a lot more complicated than traditional security token. We have this fourth prong of the Howey test, where it's really the question is,
test. Interesting.
Yeah, we'll talk about the Howey test in a minute, sure. So I see it as fairly, this case fairly consistent. I'm not that surprised. It's the way I've been advising my clients and others who I've been talking to along the way. This looks and feels like a security in a large degree to me. And of course, the court didn't get to all of the nuances that we want. The court's holding is limited to the actual facts of the case. And so if you read the footnotes, you'll see, kind of read them as I did, and feel a little unsatisfied, because we want the court to give us opinions on everything that everyone has out there, but the court's only going to opine on, on the issues that are before the court that are in legal dispute right now.
Okay, so now let's talk about the Howey test. Okay, so right now I think that is some kind of metric to determine what is a token and what is a security. So first, let's kind of try to draw a lot of distinction between a token and a security. I think this it's purely a matter of context, as it is a matter of technicality, like in terms of where these two operate. Okay, so basically, a token is not considered to be a stock, or what we consider as a share. Okay, here in Nigeria. Okay, so and now how has XRP as a cryptocurrency, as a token, how has it failed the Howey test?
So the big question, to review the Howey test, and this is an old Supreme Court case that looks at what an investment contract is. That's kind of, in the U.S. parlance, when we're talking about securities, we're talking about investment contracts. Traditionally, they kind of get pushed together. And so we have 4 prongs. So it has to be an investment of money or other consideration in a common enterprise, with the expectation of profits derived solely from the efforts of others. So typically, I hone in on the 4th prong. So what is being done in terms of the efforts? So if I give you a pile of money or crypto and you have a project, that seems pretty clearly I'm relying on you to do all of the work. The difference in this decentralized world is we have projects, we have protocols that allow input in all kinds of different ways. And so we don't have that guidance yet in terms of where are the lines, how much effort, is it a 50-50 effort? If I'm doing less than 5% of the overall effort for the organization or the project, does that mean that I'm primarily relying on someone else's efforts, or how much do I have to contribute? So I think about this in the context of DAOs, especially because DAOs that have 1,000 members, but everyone votes on every decision through the smart contract protocol, to me that looks like everyone's participating. There are a lot of traditional companies where people will just have passive investor seat, or that maybe they'll have a board observer seat, maybe they won't even vote, or they'll have a voting interest on the board, and as a shareholder, they're going to have a vote anyway. So there are a lot of different nuances for this, and so I think it's a great illustration for when this digital world that we're in and we're building intersects in a very bad way, very unsatisfying way with a legal precedent that's been around for decades.
Yeah, interesting. Okay, so I'm going to try to introduce a context to the next question now. Okay, so I briefly had a chat with Robert Lamb today, and then I asked him about how the SEC ruling, the recent ruling, affect the Utah DAO. Okay, so there is just an attempt to kind of see if it's going to really it has created any kind of reaction from the industry. So, but it told me in quote that the DAO market has dried up. And what I basically mean is that there is no activity, and I think now it's really difficult for anybody to launch a DAO project, even as it is legal in Utah. Okay, so what, in your opinion, do you think that the SEC ruling is going to have a far-reaching implication for DAOs in Utah? The ruling is quite a
Yeah, sure. So Utah's done a great job, and Rob Lamb is a close friend of mine and mentor in this space.
Yeah.
And he was instrumental. I could see his hands in the legislation, Utah DAO legislation that was passed earlier this year, and will go into effect on January 1, 2024. So I see that as some of the most forward-looking legislation that I've read across the world. A lot of the current VASP, virtual asset service provider regimes, for instance, in the Caymans, they provide the framework and kind of the general guidance. But I see the Utah DAO Act is really diving in deep into the issues that matter. You can tell that the group that was put together by the Utah Blockchain Coalition to help advise the legislators on this Utah DAO Act, you can tell that this put a lot of thought into not just what the lawyers thought was important, but what industry thinks is important, and practitioners of DAOs who have these issues, addressing a lot of issues wrap around, including, what is a DAO manager? What about DAO advisors like lawyers and others who advise the DAO or maybe even help to transact off chain? And I feel like if the SEC and courts are looking for a model to address this new fourth prong, how does this new technology enable interaction with the fourth prong of the Howey test? Absolutely, it's a great model. I don't think it's going to be a cure-all, because I'm sure there's things that were missed in Utah DAO Act, but I think it's much more forward-looking than any of the other legislation that I've seen in terms of addressing how much do the efforts of others matter, and how big is the group of people that can be involved from a foundational stage of an enterprise, because typically that's where the line is. You have a big difference between a founding team and then those who are added later as investors. So if you have a situation now where you can marry those and have the founding team expanded to include 1,000 or 2,000 or 5,000 people, what does that mean in terms of the capital they're putting at risk in the venture, putting into the war chest of the DAO, or whatever the project is going to be. So it may have to do with the timing. How early do people get involved, and maybe DAOs will have to cut off after a certain period of time and say this DAO is now closed because everyone who's in at the early stage was considered a founder, and everyone who comes in later is not. They're going to be considered investors, and they're going to blow the project apart in terms of what a security is. So it means that secondary trading could be limited significantly in those kinds of projects, but those that are planned from the beginning to be a DAO, I think could really have some legs to stand on. We're projecting out years now in terms of where the SEC, how the SEC would look at this, and whether the courts would agree. But I think that it's more the creative way of looking at this, and trying to decide, how much capital can people put at risk safely.
Yeah. Interesting. Okay, so we're on to the last question. So I'd like to know, what in your view do you think is the right approach when it comes to, in terms of regulating the crypto industry in the United States? Do you think that regulation by enforcement action is the way to go? Has that done much harm than good to the crypto industry in the United States?
It's done a lot of harm to the U.S. industry. I don't think the SEC cares at this point about the crypto industry, kind of as a viable industry. I don't think that they've shown that's a priority. I think they see it as a kind of stepchild of the greater securities industry. And so it has, the projects, I'd say I've been in the industry for a couple of years now, focused very heavily on the blockchain space. And I've seen a lot of inquiries move from, well, maybe a Wyoming DAO, maybe a Delaware DAO using Delaware LLC code to, okay, we really need to look more seriously at offshore projects. And I say that it's accelerated over the last 12 to 18 months. Initially, a couple of years ago, it had been, everyone wanted to be in the US. They were looking at perhaps Colorado collective or Wyoming DAO. And I'm getting those inquiries less frequently, where even US-based projects are looking at saying, we know that we'll be subject to US jurisdiction in some degree.
Yeah, sure.
We want as much as possible to be outside of the US. And so that's been challenging for me in a good way, I think, because I've had to digest Singapore, Switzerland, Cayman, BVI, offshore jurisdictions and I like to look at jurisdictions that are very forward-thinking on it, that are very technology friendly, and not those that are just kind of agnostic. Take a Panama, for instance, where they apparently don't really care what's going on in Panama. And there are projects that flock to those kinds of jurisdictions, but I'm of the mind that projects that set up in jurisdictions that have a clear VASP regime, where they can point to and say, we've followed the regulations as far as we can. And a lot of those VASP regulatory those guidelines are very clear, or at least are very well thought out. And so I think the projects that are based in those jurisdictions will have a much better time interacting with the SEC than those that try to go to jurisdictions where there is literally no governance at all, and they're just propping projects up based on what they think will fly, and flying under the radar in those areas.
Thank you. Yeah, so we finally come to the end of the section. I'd like to thank you for your time, Mr. Jonathan, and to once again say a good morning to you.
Thank you. It's great to catch up with you again. Look forward to talking again.